Hey, any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Welcome to the show, everybody. I'm Andy Fowler, and this is the 1-year anniversary of the In Rem Podcast. If you're new to the show, make sure to give us a like and subscribe to our channel. You can find us on Facebook, and you can find us on YouTube. On YouTube, we are at In Rem Podcast. That is at In Rem Podcast. As I mentioned before, this is our 1-year anniversary, and for you, the listener, we've compiled all of our favorite and best interviews with real estate investors and real estate attorneys. So sit back and enjoy the show.
One of the things that has come up recently, and it's been there forever, but we're seeing enforcement of it more so now, is state overlooking state-specific disclosures or even rights of rescission that aren't ending up in these contracts. So you have investors that are going and pulling these forms from who knows where. They're using them in different states, and they're not properly consulting with an attorney licensed in that state who would know those laws. And then next thing you know, they're missing things. So for example, in Colorado, anytime a properties in default and you're going to be taking it subject to, you have to give a 3-day right of rescission and certain disclosures and things like that. What kind of disclosure requirements, if any, exist in Texas with respect to subject to transactions?
Well, let me jump into before I get to the Texas marketplace,
Yeah.
that's your Colorado law with the right of rescission. I have heard just in the last 60 days that there's a lot of states that have foreclosure rescission or foreclosure rescue rules and regulations.
Yeah, and that's where Colorado is found. That rescission is on a foreclosure rescue statute.
Right. And where, some may say you have the 3-day right of rescission, some may have a 30-day right, some may outlaw it completely. I don't know. And of course, you hear that. We don't have that necessarily here in Texas. You may not have that in Arizona, but some 20 states I hear have some form of that. So, of course, I know that y'all do this. I know I try to do the same thing, too. If I'm working with an out-of-state client, it's like I can walk you through the deal and get you 98% of the way there, but you got to talk to that knowledgeable real estate attorney in your area. If you're either the investor who's buying the house or you're selling it to a third party who's buying it, someone needs to talk to that knowledgeable real estate attorney, which is hard to find, unfortunately, in this industry, who has some knowledge base about that. And make certain that if there is some issue regarding foreclosure rescue, or it might be, you're able to ensure that you navigate that appropriately so you don't stub your toe somewhere along the way. So I think you need to do that. And then, of course, here in our wonderful Texas marketplace, as you said, there's always these rules and regulations that come into place that aren't in other states. So you've got an Arizona investor trying to play investor in Texas. You got a North Carolina investor trying to play in Texas. And they don't have the same rules and regulations, and see it constantly. They think they have a good contract and whatnot. And it's like, guys, here in Texas, we have what we call the underlying lien disclosure notice, which is a mandatory disclosure for any seller to provide a buyer, whether that buyer is a consumer or non-consumer, 7 days that they can rescind the contract for any reason. And it's mandatory. And we just recently got a new Texas finance code requirement that's a a promulgated insurance paragraph, which all must be signed again prior to closing. If you don't sign these, there are problems. Here in Texas, again, because one investor out in beautiful El Paso, created all the problems for us. Now, every transaction where there's an existing mortgage in place, and the key is they don't define what the existing mortgage is. Is it a mortgage or is it an IRS lien? So since I don't know that answer, we're doing on anything that's being left in place, judgment lien, IRS lien, et cetera, just as a fail safe that's out there. But if you don't close in a law office or a title company, your transaction is not voidable, it's void. And that's pretty strong language, right?
Yeah.
That's the first one that you want everybody to understand. The second one is if you don't provide these new disclosures, and we've had the underlying lien disclosure notice for quite some time, but now they've put more teeth into it. Monetarily, it says now if you do not do it, the buyer can rescind the transaction and ask for all their money back. There used to be a reasonable rent scenario along the way. If the reasonable rent was $1,000 a month and their payment was $1,000 a month, you got nothing. But now they can come back and go, return your down payment, return your monthly payments. That means principal, interest, taxes, and insurance payments. Other damages are associated with that. And it's like, guys, do it right.
In reading the book, one thing that really struck me, and I'd love to hear your take on it. I'm sure you have one. You discussed in the book a realization moment of when being a selfless server goes from being a gimmick to actually being, a marketing gimmick to actually being something that you're doing because you want to do it. And you discuss a little bit kind of about that realization and your transformation. What was that like in realizing and moving past this just being like a marketing ploy to this is just who I am and what I'm going to be and what.
Yeah, that's a great question. And it kind of gets to the heart of the issue, which is I don't believe that selfless service can be faked over time. I think you could do it in a short run, but people have really good BS detectors and they can tell if you're for real or if you're inauthentic. And I believe that authentic selfless service is I think it's essential to long-term sustained success, especially in a service industry. I see so many people that leave, trails of burned bridges behind them. And I think it's just unfortunate. But to the heart of your question, for me, it was not an easy off and on switch, right? You don't just go from being ruthless and then all of a sudden not being ruthless. It was a transition. And a lot of it was around internal self-awareness for me, Andy, because I wasn't self-aware enough to realize how selfish I'd become. So even though I was doing things tactically to do it in a way that was following this new strategy and I enjoyed helping people, underneath it all was still this sort of manipulation of, and I think this is how most people play it, right? The people that act like they're the ones that are helping the most often are ones that are just gaming the reciprocation, paradigm, right? Just understanding that at some point the universe cannot handle an imbalance. The more you give, the more you get, which is fine. I mean, it underpins what we do. So it's not saying, hey, be naive to the fact. No, my message to business leaders is this stuff works and ultimately it comes back to you. So do it because it's practical. But also in that, if there's not a purity, right? I used to keep track. I used to be like, okay, so I helped this person. They haven't helped me back. Screw them. That's the manipulation part, right? It's the freedom of it is helping everyone. Now again, it has to be a choice, right? So no one can ever mandate that you help someone. Selfless service by its very nature has to be your own choice. But within that choice, whoever I choose to serve, it's not always just going to be someone that I assume is going to help me back. Like, I believe in spreading the service wide and far. And through that, I have gotten some of the greatest referrals from people that I never would have thought in a million years could have helped me. So the scarcity mindset is more manipulative. Like, I'll just help this person, and if they don't help me back, that quid pro quo is broken and I don't want them. So this is a broader perspective, but there's also a strategy involved, right? Like, I can sit on the street corner and I can just ask everybody that walked past me, how can I help you? And I can help them. That would probably be a cool strategy in life, but that's not what I'm suggesting. What I'm suggesting is all the people that you would normally interface with on a day-to-day basis, whoever your partners, whoever your potential clients are, your people. What if all of your interactions focused and centered around what could you do to help them succeed? What's in it for them? What if you walked around with, instead of what's in it for me on your forehead, what's in it for them? And that's what I'm really describing. And at the end of the day, I think that people can sniff out if that's inauthentic. So long story short, my journey was going from tactically starting to do the things that led to where I'm at today, and having a change of heart in the middle, where I realized in a moment of coaching with my coach that I was behaving I was still manipulating. And when I saw that, it was so ugly that I decided that I was just going to help without any expectation of return. And it was when that actually happened, when that clicked for me, and I stopped keeping track, and I stopped thinking about it, and I stopped worrying about, am I doing too much for this person? Are they not giving back? And I just said, I'm just going to love and serve. That's when it really started to take off for me success-wise.
As you're growing your business, you're learning, you're failing forward, you're learning what to do, what not to do. And they didn't tell you you'd probably have to learn how to work with professionals, whether they be CPAs or lawyers or other sorts of professionals. But what have been, and Logan, what have been the pain points as you've grown your business, as you've gotten bigger? What have been the common pain points that you've had to learn to deal with over time? Again, let's start with Pace.
I would say that I had a misconception, or I was uneducated in the realm that I should be close to my real estate attorneys. They should know about my business. They should know what's going on. And I think when you're coming up and you don't have attorneys in your family, which I didn't, I'm a blue collar dude. So we fear attorneys. We fear CPAs. We are not educated. We think these are like the scary people that you never want to have a phone call with. And then when I got into my 30s, I realized these people should be some of your very best friends that you rely on. And you can't build a business without them as your foundation. I remember I've been through more CPAs than I've been through attorneys. And it was because I would just go on Google and say, I need help with this. And I would find somebody, and I have to go through their process and their flow just to find out 3 months later they couldn't solve the problem I needed. So number one, these people should be your friend. Number two, the biggest thing that I would suggest to people when you're coming in this business, make sure you're getting referrals before you go out and search for stuff. Find people that can do things for you very specifically. That's actually, I went through 5-6 years dealing with attorneys until somebody referred Sean St. Clair to me, and it solved all my problems. And I'm like, man, that literally took me 5 years just to ultimately ask somebody for help and a referral.
Logan, what about you? What have been your pain points with professionals, but mainly attorneys, as you've grown your business?
Early on, it was kind of similar. I was stumbling through, just grabbing somebody and see if it would work, and I wouldn't have the best result. So I would open up the law books. I find these guys reading them. So I'd get subscriptions, buy books, start reading them, start going through Google. And I start to realize there's a lot more to it. So I ended up spending a lot of time learning about the law and how it worked. And it helped me project manage attorneys early on so that I knew what I was talking about. And if they were going the right direction, I felt good about it. If they're going the wrong direction, I could rope them back in. But at some point I realized I'm running a real estate business. I'm not trying to be a lawyer. So during that time, I was starting to meet better attorneys. And that really helped a lot. The funny part is I'd get my ass kicked a couple times, and I met a great attorney from the opposing counsel. And after that case was done and settled, I ended up hiring them for another case, that's how I met some of the better ones I know today from the opposite side. But I think in my opinion, I think matching is really, really important. In my mind, there are about 4 different kinds of attorneys. And if you match correctly, kind of like you're matching a spouse or a business partner or whatever, it takes a lot of the guesswork out of it. So I'll tell you about those 4 different kinds, in my opinion. There's the solo guy. He's the neighborhood attorney down the street who hangs his own shingle and might have a paralegal, maybe 1 or 2 partners. Then you have the mid-sized firms, and they've got a decent-sized office. They do some marketing. You hear about them around town. Then the next tranche of attorneys would be like the national firms. They have, 50, 100 people in each office in Chicago, New York, Dallas, Los Angeles, things like that. And then the last tier would be like the star attorneys. They're the ones that you see on TV, the Coens, the Kardashians. I don't know. Those are ones that folks would remember from big news stories. But you have to pick the right one for what you're doing. And if you're always going for the small guy who hangs his shingle, you're not going to get calls back. He's not going to be an expert on anything. He's going to do all these different things. You're going to be a frustrated client. And as I started to understand that, picking the right type of firm for my current project or my current business model made more difference than anything.
I want to talk about the foreign nationals because that's interesting. Talk to us about what that looks like from a logistics standpoint. Let's say, somebody comes to you and, hey, I'm not a U.S. citizen. Presumably, I guess they have a tax ID number of some sort, or maybe they don't. I don't know. But they come to you and they say, hey, I'm going to start investing. I want to form, let's say, an LLC, right? Let's say, that they want to form an LLC. What does that look like logistically as far as getting them set up, getting their EIN? Because that's always what I'm concerned about, right? Is, okay, how do I get this company an EIN if I have somebody that's not a U.S. citizen without maybe a social security number or whatever? What does that look like?
So foreign nationals can request tax IDs. And so it's not a social security number, but it's a tax ID so that they can actually engage in business in the United States. And there are visas that are designed purely for investment purposes, right? A couple $1 million here. Depends on the business, right? There's multiple types of visas, but if you come in and you acquire a business and you invest at least a little over $1 million in the business, and you also manage to employ 10 people through the business, then you qualify for a specific kind of investor visa. So, right, real estate is big on one of the big sources of investment opportunities here. Acquisitions of commercial real estate are really attractive to foreign nationals. And so it's getting the tax ID and also helping them understand the tax consequences of it. Because if you're a foreign national, you're not only going to have different tax treatment as far as like exceptions, allowances, that kind of thing. You're going to get different tax treatment on estate taxes owed. Very significant different tax treatment. Here, for example, if somebody's a beneficiary of the estate, right, and they are a foreign national, so not a green card holder, not a U.S. citizen, that federal estate tax exemption is $60,000. It's not the $12 million we all hear about, $60,000. So it's even more important to do, very detailed estate planning so that you can minimize the tax consequences. Because imagine, right, you own a business here, every business is going to be worth more than that $60,000 exemption. So there's really some nuance in understanding the tax laws and how they apply to foreign national investors. The other thing is that a lot of these visas require business plans as part of what gets submitted to the applicant, to the agencies that are determining whether you get the visa or not. So some of the time we do work in creating the business plans for the immigration attorneys. I don't do immigration law, just disclaimer there, right? But this is something that's a requirement. Why? Because the U.S. government wants to know, how are you going to be investing this money? How is that business plan going to result in you employing 10 people? And how is this business going to pay for that too? Real estate, like I said, is such... it's really, really attractive for foreign investors because even if the business doesn't end up working out, you can release the premises to another business. So there's that. Some opportunity out there for you wholesalers of commercial properties.
And so you do a decent amount of work then with foreign nationals. If they want to get up and running, you can assist them then.
Yeah, and I would say I have the background just because I have dual citizenship and I grew up in another country, so it kind of helps to have that language capacity with potential investors. And you just got to watch out to see what's going on with America and Central America with elections, because elections determine how much interest there is in investment here in the United States for visa purposes.
So this is a show kind of devoted to real estate investors and some of the legal topics and business topics surrounding that. But I want to start initially with the question of structure for a real estate investor who's either starting, maybe they've already started and they're questioning how they've structured their business, their assets. From a tax perspective, how do you recommend real estate investors structure their business holding to maximize tax benefits? How should they begin thinking about that?
Good question. So I would, the very first thing that I would probably want to make sure that people understood is LLCs and what that means in the eyes of the IRS. And ultimately, the answer is an LLC means nothing in the eyes of the IRS. And so LLCs are great legal tools, right? But the IRS doesn't understand what to do with them. So going up and setting up an LLC potentially doesn't do anything for you tax-wise. It gives you liability protection right in the legal side, but it doesn't do anything tax-wise. And so understanding that, LLCs can be taxed a number of different ways, just depending upon how they're structured and set up and what elections you make. So LLCs being the primary business that I'm seeing people deal with, just make sure that you understand what that structure is or how the IRS is going to view it. The next step that I would say people need to understand is how the IRS taxes different kinds of income. Primarily, we're going to fall into two categories: active income and passive income. I have clients, and I don't know if you guys run into this, but they'll call themselves real estate investors and they're flipping homes. Well, that's great.
Sure.
That's totally fine with that. I feel great about flipping homes. Flipping homes, the IRS falls into this active category. And so flipping homes is going to be treated and taxed very different than holding a property for rents. If I am trying to wholesale a property, right, that's treated differently than holding a property for rents. If I am trying to buy a property and then sell it on a seller finance note to somebody else, that's treated differently than holding a property for long-term rents. So understanding what you're trying to achieve with that piece of real estate and what the intended purpose is will determine how the IRS is going to treat it. And that then determines what the best entity type is for that transaction. Usually active transactions dealing with active income will be best done from a tax standpoint out of an entity that taxes as an S corporation. That ultimately mitigates or allows us to pay the least amount of Social Security and Medicare tax. I'm going to put a caveat in here. If you're super close to retirement and you love the Social Security system, it's not a good fit for you. But if you think Social Security is not what it was originally designed for, I'll say it that way, don't pay into it, and the S Corp is the best way to do that. For long-term rental holds, those are usually best done in either what I would call a single member LLC or sole proprietor or a partnership, just depending upon what's involved and what's going on with the property.
What the industry has defined as a wholesale transaction is basically one in which a investor / buyer enters into a purchase contract, and then they take that purchase contract and assign it to a third party, an end buyer, who then closes on the transaction, and then the original buyer / investor they receive a fee from the end buyer to assign the contract. So basically, there's a real estate transaction and there's a personal property transaction. So the real estate transaction is where you basically have a purchase contract to buy the seller's real property. However, the original buyer is not buying it. They're actually selling a personal property interest. So they're selling their right to purchase it, which is personal property. They're selling the contract. They're selling the paper.
And so we have an idea of what the wholesale is. There's a lot of listeners that are listening right now that have never even heard the term novation.
Mm-hmm.
So let's talk about that. What is a novation?
So from a legal definition standpoint, a novation is replacing one contract or one obligation with another. So it's a replacement contract. That's what a novation is. In fact,
Out with the old, in with the new.
Yes. So we learn in contracts class in law school, we learn what a novation is. And even in real estate school, they teach you what a novation is, which is a replacement contract. That's what a novation is. So out with the old, in with the new. In the simplest forms, you have a seller who enters into a contract with a buyer. For whatever reason, the seller and buyer are not going to close on that contract, and the seller then enters into a contract with the new buyer. And in that case, you would want a agreement in place with the original buyer, basically saying, hey, I'm going to close on this other, and we're going to novate, we're going to replace your contract with this other. So we're going to cancel your contract and we're going to move forward with the second contract with that new buyer.
Is this just a matter of personal preference? Maybe I've got a good novation form, so I'm just going to always do that, or I've got a good assignment form, so I'm going to do that. Why choose one or the other?
Yeah, so really it's the economics of the transaction is what's going to kind of dictate where you're going to go. So think of the novation as replacing or having the ability to replace your double escrow. What I mean by that is when you close on a replacement contract, now the transaction is closing from the seller to the end buyer via a brand new contract where that end buyer is listed as the buyer. So you may have an end buyer who wants to live in the property, and because it's going to be their personal property as opposed to an investment property, they're willing to pay pretty much fair market value for that. And so because of that, they may just want their own contract that's different than, say, an investor contract, right? So if you have a contract between the seller and the end buyer, that will more likely be similar to your standard real estate contract with, disclosures and seller property disclosure statements, inspection period, those types of things that you find in more of your standard residential real estate purchase contract where the buyer, intends to use this property as their home or their residence. So in that case, a novation may make sense because it's like, okay, I'm going to end up, selling it to this buyer, and the buyer wants to do all their due diligence because this is going to be their home. This isn't an investor who's going to want to come in and, fix and flip. So they realize they're getting a property that's not in great shape anyway, or is going to need work, etc. So that's one. The second thing is that end buyer may want financing,
which they're almost always going to want unless they're a cash buyer.
Unless they're a cash buyer. And so from a financing perspective, lenders don't, for numerous reasons, they don't want to lend when the buyer is not shown as the buyer on the purchase contract.
We've just gone through 2022. A lot's happened with the real estate market. What's the temperature of it right now? Where are we at?
Believe it or not, we went from a red hot seller, the highest the Cromford market, well, not quite the highest the Cromford market index has ever been, but second highest that it's ever been, probably. compared to 2021, which was higher. But we went from an extreme seller market, and within about 6 months, we went into a balanced market, and then we glided into a little baby buyer's market for literally maybe 3 or 4 weeks. And over the last 2 or 3 weeks now, we have actually started to see a bottoming out, and the Cromford Market Index, which is our index that we watch for heat, if you will, has been moving back into a balanced market, which basically, in comparison to where we came from, feels extremely cold. All of a sudden, buyers have time, they have negotiating power, they have options, the homes look better, they're not, dilapidated. So to have that all happen within literally a matter of months is extraordinary, for sure.
Yeah, and I think perspective is everything. There's a lot of real estate investors that were born in the boom market, right? And maybe didn't experience the last, the Great Recession that we all called it. So why don't you kind of give us some perspective, overlay kind of what that looked like in its early stages and how different this is.
I think the best way I can describe the difference between the 2007 through 2009 crash, which was a drop of 55% in price, to today, is just looking at the raw numbers of where we were prior to that crash. So in 2007, the Cromford Market Index, right around October, hit the lowest measure we've ever seen, which is 26.5. What does that mean? It means we had 57,000 active listings in the MLS, and we only had 4,000 under contract. That is where we were before prices started their crash, okay? And that was right around the beginning of the foreclosure crisis that started to see that added inventory not only being added on from lenders, from investors who were letting their properties go to foreclosure because they had made their money on them. And also on top of that, you had an excessive amount of new construction that was hitting the market because they had basically built too many specs. Okay. So that's kind of where we were in 2008. Today, we have 16,000 listings in the MLS. We have just under 6,000 under contract. So when you look at the indexes, the way they are, we always look to see what's normal for this time of year. Is 16,000 in the MLS normal for this time in December? And same thing for under contract and combining closings and all of that. So our demand line has what's under contract, which is pending, UCB, CCBS, all of those contract statuses, and also closings. And then we look at that to say, are we now within normal for December? And the fact is that both of them are below normal. They're about 20 to 30% below normal still, but both indexes are close together. Does that make sense? So when both your supply and your demand are going down together, but they're close together, you can be in balance. We don't like it as an industry because we get bored if demand specifically is below normal. So what you're seeing in the reporting is primarily on the demand side. So the last thing I saw in terms of, I think it was a Redfin predictions for 2023, they stated that demand was going to be as bad as 2008, which makes everybody think that means we're going to see prices go like 2008. Well, the reality is the prediction is true. We're already at 2008 level demand, sort of, but 2008 was rising at that point, but it's still extremely low for the industry. But the fact is that our supply is not at 57,000. So that means with the supply actually so low and declining right now, not just seasonally declining, but actually for the season, it's declining sharper than it should. You're seeing less downward pressure on price, and you're seeing a little more of a balanced state.
What about buying a business? Could I go buy a business with a self-directed IRA?
You sure can.
Really?
But there's some
Okay.
complications. There's some complications.
Oh, what
You
are
sure
those
can.
complications?
Well,
Talk to us about those.
when an IRA, whether Roth or traditional, or a 401k, or a CISA, a SEP, a SIMPLE, an HSA, anything like that, when it owns a trade or business be it a Subway franchise, tire changing company, direct mail marketing company, whatever, postcard for wholesaler company, whatever. When it owns that, it triggers something called unrelated business income tax. Now, there's ways to mitigate against it to keep it from getting beyond 21%, because UBIT is a trust-related tax, and it can go as high as 37%. But I got to tell you guys, I've seen investors go hog wild into a business for a year or two. The business was actively buying, fixing, and flipping houses with self-directed money. Yeah, they paid a third of it in taxes, but they kept the rest of it as tax-free for the rest of their life. And so they looked at it and they said, Jeff, I went out and made $800,000 flipping a dozen houses. So yeah, I paid $250 in taxes, $260, $280 in taxes, but the rest of it stays tax-free for life and grows wherever else I put it. And they go, compare that to making a $6,000 a year contribution. I go, yeah, you win. You're right.
So I know you're familiar with subject to transactions. And
right.
So if
you must be reading my email list, brother.
If somebody took their self-directed IRA and use that for the earnest money, maybe to bring some amounts current, et cetera, and then take a property subject to, using their self-directed IRA, property appreciates, they throw all that money back into the self-directed IRA. Does that work? Or is there that other tax that you referred to,
there's the kissing cousin of that other tax that's there,
okay.
but it still works. And I can show you the workaround too, if you want. Okay. You can do those deals. You will then trigger something called UDFI, unrelated debt finance income, so that the IRA will pay taxes just like UBIT on the portion of the profit that's related to the amount of debt involved. So for example, the IRA's got $50,000 in it and it takes over a mortgage of $450,000. So it's got and it puts the 50 in to bring it current. So it's a $500,000 investment. 450 is leveraged through taking a debt over subject to. So then 45%, 90% of the investment profit would be subject to UBIT. 10% would not be, because that's the IRA investment. But once again, guys, if I go do a home run deal that I otherwise couldn't have done and I make $100,000 in profit, am I willing to pay 30% on 90% of that 100,000? Yeah, I am, because what I've done is I've made $70,000 tax-free net into my IRA. Boy, that don't suck.
What is a land trust?
Well, a land trust is a title holding trust primarily used for anonymity of ownership, although there are some other uses we'll talk about. Primarily your topic about a seller signing an executory contract, I'll get into that. It's a revocable living trust. It's in that category, but it's not the same animal as you would use for estate planning. It was invented in the 1950s by Chicago Title as a way for them to get fees as being a trustee by saying, hey, you can have anonymous ownership in a trust and we'll be the trustee and charge you a fee every month. So that was the animal that was created, and close to 40% of properties held in Cook County are in land trusts. It's statutory in about 9 states. Florida comes to mind, Indiana, and a handful of others. But by common law and court cases, it's really a valid thing to use in almost every state. There's only 2 states where courts said we don't recognize these here, and that's Louisiana and Tennessee. And it was over a jurisdictional issue involving a state tax. But, as you know, the Uniform Probate Code says a trust may be created for any lawful purpose, and a land trust is nothing more than a revocable living trust to hold title to a single piece of property, with the idea of each property being under a separate anonymous trust with a trustee of choice who would normally be a family member or friend with a different last name to keep anonymity at a P.O. box. So tenants, code inspectors, attorneys, the government, anyone who wants to poke around makes it difficult.
Now, anonymity is obviously a big benefit. These days, as land trusts have grown in use, is that still the primary benefit? What are some of the other benefits, if
Yeah.
there are any, to land trusts?
The primary benefit is anonymity. If you have a tenant and you have a property manager, you don't want to be on record as the owner. A lot of people use LLCs, but they form it themselves and they put their name all over the filing record, so easy to find you. So titling in a land trust with often the beneficiary an LLC or something like that for protection as well. But there's no requirement under state law that a trust have a registered agent in the state. So it could be a PO box, out of state, out of the country. And the individual doesn't have to reside or register to do business in that state. So logistically, finding information, getting service of process in a lawsuit, everything becomes more difficult. And that's the whole idea.
I wanted to touch base on your use of the term revocable, because that has some significance, right?
Right.
You know, and so we have some, obviously most people that watch the show are not attorneys. They're going to be, you know, investors or lay people. What's the significance of the term revocable? What does that mean in layman's terms?
Well, in layman's terms, it means you can change it, terminate it, amend it, as opposed to irrevocable, which once you set it up, that's it. You can't change it. Both of those are subcategories of living trust. People think living trust, they think estate planning. Living trust just means a trust created while you're alive, as opposed to one created by a will. So living trusts are revocable or irrevocable. And of course, under those categories, there are dozens and dozens of subcategories of trusts. But a land trust is, in essence, a revocable, created while you're alive, living trust.
What kind of mistakes have you seen with regard to vague contracts, and what are steps investors can take to ensure not to make those mistakes?
Probably one that stands out that I see a lot of is finance contingencies. You know, it's like we make good faith effort to go find a, you know, company to finance this deal. What does that mean, right? Like, you know, and how do you disqualify the deal from a financing contingency? So that's one, you know, because it's like, hey, I got a broker lender that's willing to write me a letter to be like, yeah, this deal stinks, I can't lend on it, you know. So that kind of ambiguous situation I could see being a problem. I've never had a deal where anyone actually sues for that kind of good faith effort, but that's one that's squishy, right? It's kind of like, well, what does that even mean? You know, how do you qualify for that sort of thing? And that's never well defined. It's just like, hey, give me some time. And that's usually to the buyer's benefit, right? Because if it's a bad enough deal, like a lot of these value add deals are, you know, a lot of banks are like, hey, the occupancy is too low, or it's I've had deals go sideways like a week before closing because there was a like a gunfight, you know, at the apartment complex and that sort of thing. That's never defined, right? But that obviously changes the contingency. Now, does that mean, you know, that we should be able to get out of the deal because no longer get a bank? Well, no, there's got to be a bank somewhere. So that's a big one I've seen be a problem.
Well, one of the ones that I've seen that creates issues is dealing with the timing of close of escrow when there's like title issues. You know, escrow shall be automatically extended if seller can't clear title. And it's like, okay, a couple of things. For how long? Right. You know, it doesn't say for how long. And then second, what does clear title mean? Meaning sure. You and the three of us know you never take clear title. You know, you always take it with, you know, CC&Rs or maybe a utility easement or
sure,
something like
easements
that.
Galore, right?
Yeah, that you're willing to accept, and it's fine. You'll go forward. So, what does clear title even mean when they put that in there, right? And so, it's those types of things that you know, I think create issues because then, you know, the seller could come back and say, well, I have clear title, and the buyer's like, well, I
Yeah,
don't want that
I mean-
easement or this or that. And it's like, no, everybody's going to buy it with that utility easement, type of thing. So
Yeah, it's really, they mean clear to close. The bank's happy enough to give me the money.
Correct.
It's not,
Yes.
nobody cares. They're just like, what can I do? What do I get to close? And it brings up an interesting point. I've said a few times on the internet lately, is just because a bank's willing to lend you money on a deal doesn't mean it's a good deal. Banks are in the business of making money too. So, they're willing to kind of roll the dice maybe on a few deals, but just because it scratches a bank's underwriting and they're willing to fund the deal doesn't mean you're ever going to make any money on it. Doesn't mean that you're going to be able to support the debt, right? It's all subjective on kind of what a good deal is. So just as kind of a side, I would like stress that to everybody. Just because a bank's willing to give you some dough doesn't mean it's one that you should be spending a ton of time on.
Well, everybody, that is our show. Thanks so much for joining us, and thanks so much for being with us this last year. Couple of reminders, make sure to join us for our Creative Finance Symposium this Thursday, May 4th. And also make sure to join our show next week. We're talking about building a real estate business. And on that show, we're going to have real estate investor Brent Daniels. We'll see you next week.